Costs hearing in the cause of PricewaterhouseCoopers appellant against SAAD Investments Company Limited and Singularis Holdings Limited against PricewaterhouseCoopers Bermuda.
Mr. Chillis.
Thank you. I appear for PwC. My learned friends, Ms. Toob and Mr. Robbins, appear for SAAD and Singularis.
Right. I seem to have Lord Mance's papers, but now he has them. That's fine. Yep. Thank you for turning up. We have fairly full submissions from you, but it seemed to us that this application raised points of some potentially general significance in terms of the effect of orders which subsequently get revoked or set aside, which are partly complied with, and also possibly in relation to insolvency. So we thought that it justified a short hearing.
Very good, my Lord. My Lords will be aware then that the orders obtained on the 4th of March 2013 by the JOLs were wide-reaching, but of course, and is inherent in their main judgment, could not have been obtained in the Cayman liquidations in which the JOLs had first been appointed. The orders were obtained ex parte and subject to an extension of time which was made inter partes and subject to intermediate stays granted by the Court of Appeal and by the Privy Council. Those orders remained extant until the conclusion of the proceedings. Now, the orders contain no provision for the payment by the JOLs of any costs of compliance, and there are three reasons for that. The first is that the JOLs didn't raise the issue of payment of costs at the ex parte hearing.
That can't have lasted very long.
No, that's the first reason.
Yes, but it's evaporated once you get in front of the court. No costs were incurred by then, were they?
My Lord, that's right, but if one's asking why the order didn't contain any provision, one answer is because it wasn't addressed when the order was first made. That order continued in the form that it was made, save that the time for compliance was extended inter partes. The second reason, and it comes to the inter partes hearing, is because on the inter partes hearing, the learned judge didn't deal with the issue, though it had been raised by the respondents. So, because he didn't deal with it, such error as it was or may have been in respect of the ex parte order continued.
So what submission was the respondent being who? Pricewaterhouse?
The respondent being Pricewaterhouse, yes.
And so, and what submission did it make?
The respondent in their skeleton argument had said this order should not be made without provision for PwC's costs of compliance. But the learned judge didn't address that.
And that was concerned with the cost of complying with an order which was assumed for the purpose of the costs of complying of being valid.
Yes.
Yep.
In other words, not costs on the basis that the order was improperly made, but costs on the basis that the order was properly made.
Not a sort of cross-undertaking of the sort that's familiar in an interlocutory context.
No, correct, man.
Oh well.
The third reason is because the Court of Appeal, when the point came before the Court of Appeal, considered that there was no prior authority.
That again is dealing with the liquidation, insolvency point, rather than the order shouldn't have been made.
Yes, the question of whether it should have been a condition of the orders.
Yes.
That cost should be complied with.
Yeah. Thank you.
So, although PwC was not...
So what did the Court of Appeal, did they decide this issue?
It was one of the grounds of appeal.
Yeah.
That the orders should not stand unless there was a provision for the cost of compliance. And the court...
As one might say, the Weinlott-Hoffmann issue, as it were.
The Weinlott-Hoffmann issue. The Court of Appeal said they would not allow the appeal on that basis because there was no prior authority. So, although PwC was not in the event required to deliver the documentation of the information that it had prepared, it was required to prepare it and it incurred cost in doing so. So the starting point is to consider the capacity of the applicants SAAD and
Do
Singularis.
we have that decision of the Court of Appeal?
The Court of Appeal decision will be in the bundles.
Yeah.
And we'll
Perhaps you
find,
could give us a reference.
we'll find that reference. The capacity in which...
For this hearing. Yeah. Is it in the bundle for this hearing?
Yes, bundle A, page 82.
Thank you. Yes. Yes, indeed, 81 to 82. Thank
Yes.
you. Was any order or cross-undertaking sought when the stay was refused, or when the stay was granted on very limited, in a very limited way?
Not to my recollection, my lord.
Because isn't that really your complaint here? That you were being required to comply with an order which, in the end, wasn't one the court should have made?
My lord, that's one basis of the complaint, yes. The other basis is that we should have our costs even if the court order was properly made.
Would you say if it was improperly made, that's an a fortiori case, would that have been embraced by the form of order which you were seeking, or form of undertaking you were seeking?
Yes, because there would have been costs incurred of compliance, therefore the order that we were seeking as a condition.
So it'd be whether you were seeking an undertaking to meet the costs of complying, whether or not it should ultimately prove to be a valid
Yes.
order, and a fortiori, in a sense, if it should prove to be invalid.
Correct. That's right.
On one view there, the order that would have been made by the court was on the liquidator's undertaking or cross-undertaking to pay your costs of doing so. You must, pursuant to the insolvency legislation, provide them with information. If on appeal that order was reversed, then it might be said that the cross-undertaking fell away as well. And what you needed was a separate cross-undertaking to protect you against the order being invalid. An unusual thing to do in relation to a final order, but one that may be appropriate where you're seeking to appeal it.
My lord, I understand the point, and there is...
I can see the attraction of saying, look, that's ridiculous, because if you get the cross-undertaking assuming the order's valid, surely the cross-undertaking must apply if it's invalid.
Yes, the point is that if the undertaking has been given to pay such costs as have been incurred, and those costs have actually been incurred, then the undertaking stands in accordance with its terms. The fact the order is subsequently set aside shouldn't make any difference.
I mean, you can't set aside history, and if the order is enforced before it's set aside, then it was enforced because it was valid until it was set aside.
Exactly.
And I suppose you could say that the order has two aspects.
Yes, and my lord, one of the points that I will come to is that if it is right to consider this application in terms of, as my learned friends say, equivalent to a Section 236 English application where there is authority, if it's right to consider it in that context, then we say that the court in any event has a discretion whether to allow the costs to be incurred, and that discretion, we say, could be exercised even if the order had been set aside.
Yes.
But
It seems
on
to
appeal.
me what you can say is you've got two strings to your bow. Is one, the order should have been made in relation to the 236 application, as you can call it, and it would have been effective even if the 236 order was, as happened, set aside by us.
Yes.
The second is that you should have had the benefit of an interlocutory cross-undertaking, or the equivalent, to protect you against the order being set aside,
Yes.
as if it, in the same way as you get a cross-undertaking to protect you against interlocutory injunction.
Yes, well, that's right.
Those are your two arguments.
That's essentially it. And I think that the following questions arise. I'm not proposing to go through each question in turn and answer it, but I'd just like to raise these questions with the court as I see that,
Thank you.
that are relevant. The first is, should the disclosure orders be treated as Norwich Pharmacal type orders, where the applicant must undertake to pay the costs of compliance as a matter of course, even if the orders were properly made?
Yep.
The second question, and it comes to this duality that my lord was just mentioning, should the disclosure orders be treated as mandatory injunctions, where the claimants should have given cross-undertakings in damages to cover the event that they should not have been made?
Yes.
Thirdly, as an alternative to 1 and 2, should the orders be treated as orders equivalent to Section 236 orders in the United Kingdom? In other words, should they be treated as valid 195 orders in Bermuda,
Yep.
where the court has a discretion to require the costs of compliance to be paid? And if so, how should that discretion be exercised, where the orders have been set aside following partial compliance?
Okay.
And fourthly, should the two orders be treated differently on the basis that in SAAD there was a winding up in Bermuda, and therefore an undoubted Section 195 statutory power, albeit that the winding up itself was flawed and subsequently set aside, whereas in Singularis there never was a statutory power.
So 4 is really an A and B to 3,
Yes.
in a sense. The fourth point is a subset of the third.
That's right. And then, if undertakings of any description should have been given, but were not given, then firstly, can the court imply undertakings as a matter of usual practice?
Yep.
Or are the JOLs, at least in SAAD, where they were officers of the court, required to behave as if they had given such undertakings as should have been given?
Yep.
That's how I would frame the issues that the court has to consider.
Thank you.
I'd like to, you have our full written submissions, and I'd like to address, therefore, the objections that the JOLs have raised to the order. They appear to be as follows. Firstly, they say, treat these as equivalent to Section 236 orders, where the respondent is not automatically entitled to the costs of compliance.
Yep.
Secondly, they say, well, the JOLs didn't actually give any undertakings to the court, and even if they should have done, on reflection, no obligation can now be imposed on them. And thirdly, the rule in ex parte James has no application. So if I can deal with those three objections. The first is the 236 equivalent, and this appears from the JOL submissions in Bundle A at tab 2, page 182.
Thank you very much.
And they're succinctly set out in summary.
Sorry, page.
182.
182, it's paragraph 19.
Yes.
Paragraph 19.1, this is their summary. Persons against whom a disclosure order in a liquidation, such as 195, can be sought, have a public duty to assist. That's their first point. Well, as far as that's concerned, it can't apply to Singularis, where there is no winding up in Bermuda. So as far as public duty is concerned, the JOLs were Cayman liquidators, and the public duty to assist that PwC would have had as auditors must be a Cayman public duty. It can't extend beyond that which they were required to do in Cayman. And as we know, what was being sought in Bermuda went beyond what was required by the public duty in Cayman. So there's no further public duty to consider in Singularis. So far as SAAD is concerned, where there was a winding up in Bermuda, there may have been an ostensible public duty in Bermuda, although as we can now see from my Lord's judgment in the main case, in Singularis, that in fact there was no public duty in play at all, since the liquidation itself was flawed. So, to the extent the court can decide after the event whether costs should be paid, that may be important. Paragraph 19.2, the court retains a discretion to order costs of compliance, but should not regularly do so. I object to the word should, but apart from that, I've nothing to cavil with on 19.2. Of course, this isn't a regular case. It's wholly exceptional, as I think my Lord's recognised, and I think the insolvency community at large has recognised this is an exceptional case. And the costs of complying with an order that should not have been made in the first place can never be considered a regular case. Paragraph 19.3, any decision to exercise its discretion to order costs of compliance should be exercised at the time at which the compulsion order is made. Now, that is simply inconsistent with the authorities that are relied upon by the joint liquidators in Bundle B. And I'll quickly take you to them, if I may. Aveling Barford, Bundle B, tab 3, page 221, at 366E to G.
Sorry, say that again, William.
It's
221.
221 is the
Tab
bundle
3.
reference, and the authority reference is 366 at E to G.
Thank you. Sorry, what's the bundle reference again?
221.
B3, page 221. And you'll see the passage headed costs. Aldrich Chapman were asking that they should be indemnified against all costs incurred. And at E, Mr. Justice Hoffman said it would be premature to make an order for the payment of the costs. An order under section 236 seems to me to have stronger analogies with the subpoena ducis tecum or ad testificandum, by which a citizen is required to perform a public duty than with, say, a Norwich Pharmacal order or Morava. I see no reason why there should be a presumption under 236 any more than under 561, respondents entitled to be indemnified. I do not, however, wish to say anything to inhibit Aldrich Chapman from making an application for costs at an appropriate time, which would, in my view, be after they fully complied with the order. So that's inconsistent with 19.3 and suggests there is an exercise of discretion which the court can make at the end of the process. The same appears from the BCCI case, which my learned friends have put in the bundle at B, tab 4, page 240, bundle reference.
Yes. Next tab, yep.
Next tab, 240.
And that's at F, is it?
It's at F, and you'll see Mr. Justice Robert Walker there dealing with Aveling Barford, dealing with the views of Mr. Justice Viney.
Sorry, I'm not with you. Again, Robert Walker in the next tab where?
It's next tab, page 240.
240.
And you'll see at F, Robert Walker's considering Aveling Barford, Clover Bay, and at G, expressing the view there's no presumption. Seems to me, at H, if I have jurisdiction to make such an order, I should in this case follow the course indicated by Mr. Justice Hoffman, defer any decision, and then expresses no final view as to the views between the two judges. However, it'd be surprising if costs couldn't be awarded where production of documents is required. Then Harvest Finance.
Is that the same sort of costs as the present costs?
Yes.
It is.
Yes,
It's internal costs. It's not costs in a formal legal.
No, you'll see it at H, where the learned judge is talking about costs of express air freighting up to 100 boxes of 2,000 pages of documents each. It's clearly not legal costs. At 240, right at the bottom. You'll see the sort of costs that are being referred to there.
And he leaves open the question, the difference, the view as the difference between Justice Hoffman and Justice Weinrock, but tends to favour Miss Justice Hoffman.
That's correct.
In the next paragraph.
That's correct.
Yeah,
And
okay.
at tab 9,
Thank you.
the decision of Mr. Registrar
Oh, yes,
Jones
that you refer to, yes.
in Harvest Finance, which again it looks at the two cases and tends to conclude that at paragraph 36 on page 303, the practical result of the two decisions doesn't really differ, subject to the very exceptional circumstances test. But at any rate, what is clear is that this was itself a case where after compliance, costs were being sought. So this again was at the end of the process. So the cases relied on by my learned friend don't support the view that the decision has to be made at the time which the compulsion order is made. It is open to the court to make an order following compliance and after the costs have been incurred, when it no doubt can take all considerations into account.
In favour of what? In favour of the person who's having to
Comply.
Who's having to comply, yes. And So applying by analogy the cases relied upon by the JOLs here, firstly, there is a power to order payment of the costs of compliance. Secondly, that power will best be exercised at the end rather than the beginning of the process.
And these are costs not limited to legal costs, but would include legal costs, would they?
Yes.
So effectively they're retrospective.
They're retrospective. And we've seen Mr. Justice Hoffman, Mr. Justice Robert Walker say, let's see what happens, let's see what's incurred, and come afterwards to get your costs if we think you're entitled to them. Here, we are at the end of the process. The costs of compliance have been incurred pursuant to orders which were effective and binding at the time the costs were incurred, but we now know should never have been made. PwC...
What is the argument for leaving it to the end of the day? I mean, it seems rather odd. The people have to do the work without knowing whether they're going to get an order for costs, and the order is applied for and will be made without knowing whether you're exposed to covering the costs. Why is it left at the end of the day? That's not normally the way things are.
Well, that's what those cases suggest, and that's what has happened.
They're first instance cases.
The rationale of this is that it's a public duty to assist. If the court makes an order that the costs be paid, that is, so to speak, largesse. And in those circumstances, one should wait and see what sort of costs are involved. I mean, it might be a factor going to the discretion, for example, whether somebody was being asked to turn his business upside down at very, very great expense, or whether it was a relatively straightforward matter.
Yes, and my Lord, it may be that with the analogy with legal costs, courts are reluctant to make preemptive cost orders. They like to see how things work out.
Giving blank cheques.
Before they actually make the order. But there it is, my Lord. The position may be that the position should be addressed at the outset, and of course that was our submission below, that the orders should actually have been conditional upon the payment. We weren't asking at that point for the matter to be addressed after the event. But it's my learned friend's submission that I'm addressing now.
So what you say is that the conventional approach to these sort of orders is that the court, if it's minded to, makes an order that, under Section 236, that the respondent complies and considers the question of the costs of compliance after compliance has taken place at some appropriate time.
My Lord, I would hesitate to go far and say conventional. I would say this is what has been shown by the authorities that my learned friend has produced to the court in support of her case, which apparently is that the order should be made at the outset. Now, I can see that there are policy reasons, which my Lord Mance has indicated, which may indicate it's better to do it at the outset so everyone knows where they are, and that the liquidators, for their part, can say, well, look, if that's the cost, we don't want to proceed with the order. If we now know we're going to have to pay these big costs, we can decide now not to expose ourselves to that risk.
Equally, I suppose the contrary argument, there may be a sort of faint suspicion that if you're asking for material from, in the case of Avering, Barford, the solicitors to a failed group, and in the case of Bank of Credit and Commerce International, BCCI, some bankers to it, maybe when they produce the documents, it'll prove that they were all mixed up in some way in the collapse of the group and don't look quite so independent or meritorious. Is that a possibility?
It's a possibility. Certainly there are references to innocent third parties not bearing costs, people who aren't themselves to blame. So that's certainly a matter that might be taken account in the discretion of the court.
Because if you make the order at the outset, you rather lose the discretion, don't you?
Yes. But what we say here simply is that PwC can't have been under a public duty to assist the JOLs further than that which they were required to do under Cayman law.
But
so the public...
I'm just wondering if this is right. Is this an application to make to us? I mean, don't you make it to the court that made the order?
Well, if that is the correct analysis, as my lords appreciate, our primary case is that this isn't That's not the correct analysis, and that there should have been.
You say it should have been made at the beginning.
And it should be treated now as if it had been made at the beginning. But if my learned friend's analogy is right, and that these flawed 236 orders should be dealt with as real 236 orders, or real 195 orders, notwithstanding the unusual circumstances in which they came about, then we say, well, that's the answer, and there can be no exercise of discretion other than to require payment where the orders were found to be flawed, because there can be no public duty argument at all, and therefore someone has been put to expense without any public duty to justify them having to bear that expense themselves. And that's what we...
I see. So this is really saying, well, if she's right, then those authorities show that the cost order can be made now, and given you're here anyway, we may as well make it.
Yes. Okay. And one can note, incidentally, if my learned friend is right, and the costs of compliance should ordinarily have been dealt with on the making of the order,
yes,
as she says, we know it wasn't. And on the ex parte hearing, the liquidators didn't raise this.
But on the inter partes hearing, did you?
Well, we
Yes.
raised it on the inter partes
Exactly.
hearing.
Oh, I see. We didn't raise the. Sorry. What?
So the liquidators didn't raise it on the ex parte hearing, although they assert now that that's when it should have been dealt with, when the order's made.
Yes, but what about my Lord's question, which I rudely interrupted?
On the inter partes hearing, PwC raised it and said, don't make this
Yes.
order, but if you do make it subject to payment of the costs, and the learned judge didn't deal with
Yes,
that.
I mean, I do think that your inter partes point is problematic on causation grounds.
The ex parte point.
Ex parte.
The ex parte
The ex parte
point is
point.
problematic on causation grounds. I mean, it's water under the bridge because no costs were incurred pursuant to any failure at that stage. And once you've got to the inter partes stage, the real reason why the present problem exists is that it wasn't dealt with then when you raised it.
In one sense, I understand that it's a matter of causation, save for this, that if anyone is at risk proceeding forwards,
Yeah.
if anyone is at risk, the question is on whom the burden of that risk should fall.
If it hadn't been raised by you at the hearings, it hadn't occurred to you,
Yes.
then there might be something in the point that if they'd done what they should have done, if you're right, at the ex parte hearing, it would have been on the menu, then I would have more sympathy with it. But since you raised it at the hearing, I must say I share Lord Nance's view.
I understand that entirely, my lord, but
But you say it's not a good start for them.
It's not a good start, and if it had been raised at the outset, the learned judge really would have had to have dealt.
Anyway, the learned judge didn't deal with it, even though you raised it.
Yes,
And the Court of Appeal dealt with it in paragraph 62 and 63.
that's correct.
And you say we should allow your appeal against that conclusion that they shouldn't have, the conclusion that they shouldn't order that the costs be paid.
My lords,
That
that's beside the point. The appeal has been allowed. It's not allowing that appeal on that ground won't help us. The question is, what's the consequence? The question is, the Court of Appeal wasn't being asked to direct payment of money. The Court of Appeal was being asked to quash the orders on the basis that no cross-undertaking and damages had been given, or no obligation.
I see. Well, that's what I was going to ask, yes. That was...
So the issue now is that requirement not having been put in place by a lower court.
Well, the way it's put in paragraph 63 is I would not make an order that the joint liquidator, it's page 82 of the bundle A, I'd not make an order that the liquidators be responsible for or give an undertaking.
Yes.
So the Justice of Appeal Bell seemed to be assuming it was put in two different ways. One was an order and the other was a cross-undertaking, or an undertaking. I can see difficulties in your way on an undertaking.
Yes. So far as the order is concerned, we do ask for an order from this.
But is this strictly an appeal against their refusal? This is what I'm sorry to press, but is this an appeal against their refusal to make that order?
And if not, why not?
Well, does it need to be, as opposed to being a consequential order? I mean, if money has been paid pursuant to a judgment that is overruled, the ultimate Court of Appeal that overrules it will direct, as a matter of inherent jurisdiction, repayment of that money. simply as a consequence of its
And, my Lord, we have come here on the consequential basis. No application had been made to the Court of Appeal for payment. I think that's why it's difficult to talk about appealing from it, notwithstanding how it's expressed in the judgment. We didn't apply to the Court of Appeal for payment. We applied to the Court of Appeal to quash the orders below on the grounds that no undertaking had been provided for. So there was no extant application before the Court of Appeal that the costs be paid. And in that respect, my Lord, I don't think this isn't an appeal from that decision.
So, I mean, you have got a problem then in pursuing the Aveling, Barford and BCCI line.
Well, my Lord, I don't think we've got a problem in the sense that...
Well, you could pursue it in front of the first instance court, perhaps, but how can you pursue it in front of us if you didn't ask the Court of Appeal for an order for payment of the costs?
Well, simply because the question of payment, if it's to be dealt with at the end, if it may be dealt with at the end of the process, we're now at the end of the process. Our grounds...
But it's a fresh application. You're at the end of the process, and you say at the end of the process it's free to you to make a fresh application, but you can't make it for the first time in the ultimate appeal court, can you?
I'm not sure about that, my Lord.
Well, it's not enough to be not sure about it. I mean, you have to persuade us that you...
Well, my Lord...
But why not?
My Lord, quite simply, if this court, upon quashing an order, has the powers of the courts below,
Right.
then it has the power to order
It'll
payment.
surely have jurisdiction. Whether it should exercise the jurisdiction or remit it to some other court is a matter for the board.
But, my Lord, there must I would suggest, be jurisdiction in this court to make any order which the courts below could have made, and it would have been premature for us to seek payment in the Court of Appeal, where the ground for payment, the key ground for payment, is we've now established there's no public policy argument.
Slightly quaint for us to be invited to make an order which is prima facie for the court below to make, and an order which assumes that an order we've just held to be wrongly made was rightly made.
My Lord, it is slightly quaint, and that's why it doesn't appear in our written submissions, and it's a point that arises out of my learned friend's response to our written submissions. This has been all on the basis that if you proceed down the 236 analogy, this is where you end up. It's not the way we set out to ask this court to make the order. And perhaps I can move on now to the implied undertakings aspect. So to the extent that the 236 objection is either put on one side as
Can I
not...
ask, does this apply to both cases? Or?
The implied undertaking?
No,
the 236?
Yes.
Well, Lord, I've suggested that it may apply differently,
yes,
because in one there was a winding up, and therefore there was an undoubted power under Section 195. In the other one, there was no winding up, and there was no power under 195. And therefore the order that was made was undoubtedly made at common law in Bermuda. And that brings us on to mandatory injunctions or disclosure orders or whatever, Norwich Pharmacal, at common law. And that's where we come, I think, more into implied undertakings.
Sorry to go back to this first point, but what was the basis on which Mr. Justice Vianot, Mr. Justice Hoffman and Mr. Justice Robert Walker were being asked to make those orders? What was the legal basis of it?
The legal basis was that under the Act and the rules, although the relevant rule, I think, is equivalent in the Bermuda Act, there is a power to summon witnesses and require documents. And the express provisions of the statute say, and you can pay the expenses of a person coming as a witness, but it says nothing about the expenses of providing documents. And that's the issue, I think, on which Mr. Justice Vianot and Mr. Justice Hoffman and Robert Walker differed, as to whether the statute allowed that power.
So there had to be a statutory basis. There was no inherent jurisdiction.
They were proceeding on a statutory basis there in respect of the statutory power. When we move to Singularis, and there's no statutory power, we're simply left, even in Bermuda, with a common law order that was made. And therefore we have to address, well, how do we deal with the common law compulsion order where there is no statutory basis, and we say you couldn't in any way apply the 236. And that's where we come on to implied undertakings, because we know no actual undertaking was given. And so we say...
But just go, for example, in Norwich Pharmacal, it's just a rule of practice, is it?
Yes.
Only?
It's a rule of practice, and it's a rule of practice in moreover injunctions and as what. It is a rule of practice.
But it was, it's a mandatory rule of practice.
It's a mandatory rule of
The
practice.
House of Lords in Norwich Pharmacal made it clear that that was the basis on which they were deciding that such an order could be made.
And that's why we say that it's something that is implicit in the order. If you seek a Norwich Pharmacal order and you don't say to the court, I will undertake to pay the costs of compliance with this order, even if you haven't said that, it can be written into the order. And if it's not written in, it can be put in under the slip rule. And that's what we say.
Yes, you have to deal with a forceful further submission by the opposition, don't you?
That's what I'm coming to, if I may, my Lord. We say either the indemnity, if it's a Norwich Pharmacal basis, an indemnity as to compliance should have been given, or if not, then a cross-undertaking and damages should have been given. Either way, we're looking for the basis upon which the JOLs can be regarded as obliged to make that payment. The first point is the orders were obtained ex parte, as we know, and I've heard what has been said about that, but it does appear the issue of undertakings wasn't raised expressly with the court at all on the ex parte basis, notwithstanding the obligation. Now, it appears from the JOL's latest submissions at A4, bundle A4, bundle A, tab 4, page 203. At 28.2, that the joint official liquidators were not willing to give an undertaking as to damages.
Yeah.
Now, if that was true at the time of obtaining the ex parte order, then the question of giving an undertaking as to damages was in the minds of the JOL, and they decided not to raise that with the court.
Where is that dealt with in the body of the text? The summary. It is dealt with somewhere, I know. I just can't remember where. Don't worry, if you haven't got it to hand.
No, I haven't got it. No.
Don't worry, I don't want to take up time.
My Lords, the practice of giving a cross-undertaking damages on obtaining an injunction was clearly so well established by the end of the 19th century that it didn't need to be mentioned in court at all. We can see that that was the case in 1890. It appears from the Spanish General Agency case, which is at tab C, bundle C, tab 1, page 549. Over the page, 550, Mr. Justice Kekowicz. It's the first part of his judgment. And I think second sentence, nowadays with those who are acquainted with the practice, it's really unnecessary to mention undertaking damages at all. In the ordinary course, it goes without saying. So that's the goes without saying basis.
Yes, I mean, the difficulty about that is that here it clearly didn't go without saying because it was said and refused.
Oh, no, my Lord, that's not quite right, with respect.
In the present case, you raised it when the matter came in front of the court inter partes, and you weren't given, or an undertaking wasn't required in your favour.
But
Well,
my Lord, it wasn't dealt with.
Hey, but wait a minute. What we're concerned with here is the final order made by the Court of Appeal, which is what you complied with, isn't it?
No, we'd already complied by
Sorry,
that.
you complied with the High Court order.
Yes,
And that was the final order or the interlocutory order?
that was a final order.
But then what has this got to do with it? Because that was a final order, and you don't get a cross-undertaking of a final order.
My Lord, we start off with the
I know you start off, but what was the
Well,
order?
my lord, if it's a Norwich Pharmacal, you do get a undertaking.
Well, that's a different matter. But this is dealing with ex-party orders.
Yes.
We're not talking about an ex-party.
Well, my lord, we're talking about an order, a final order made ex parte, if I can put it that way. The 236 practice, as was said to the learned judge at the time,
Was it made ex-party in this case?
Yes, my lord. The 236 order is made ex parte, and it's final. It doesn't.
Then it went
It's
into...
not interlocutory. It's not over a period.
Then went into parties.
My lord, it went into parties on our application to discharge.
Discharge.
My lord, the application never went into parties.
Well-
It was a final order made ex parte. We then applied to discharge, and there was no discharge.
And did you ask for a cross undertaking?
My lord, yes.
So what is this?
Well, my lord, we asked for the cost of compliance.
Isn't
Yes.
the right procedure to ask for a stay?
Yeah.
Well, my lord, we asked for an extension of the time. First of all, we asked for it to be discharged altogether, and the learned judge wasn't prepared to do that. He didn't stay it, he allowed time for compliance to be extended for 4 months. The Court of Appeal subsequently stayed it, and this court subsequently stayed it. But the learned judge never stayed it, my lord.
Yeah, but if it's a final order, what Miss Justice Kekowicz is talking about is a classic interlocutory order.
My lord, it is.
An ex-party order.
My lord, and this was an ex parte order. And the question is, if it is an order which should carry with it an undertaking to pay the costs of compliance, then that undertaking must necessarily have been made at the outset.
So if liquidators apply for a Section 236 order, ex-party, they have to give a cross undertaking. That's your argument.
My lord, I've dealt with Section 236. What I'm saying here is if we're out of 236 and we're now dealing with a common law application for the disclosure of documents, then yes, they do. On a Norwich Pharmacal basis.
Did you do
It's
anything
compulsory.
to comply with it before you, the sum you're claiming now, did you do anything to comply with the order before you applied for it to be stayed or set aside?
Not that I'm aware of, my lord.
It may have been a little bit.
There may be something, but I think
That's
the
not
substantial.
part of the thing.
We're not concerned.
So you get back before the court. The 236 order you accept, or whatever, 195 order, whatever the order is a final order.
Yes.
And it's argued between the parties, and the court makes the order.
No, my lord, the order was
Well,
there.
the court
Refuses
the
to
court
set it
refuses
The court
to set
refused
aside
to
the
set aside the order. The order is there.
How does it become like an interlocutory order, then, which is what this sort of thing is concerned with?
Well, my lord, what we're concerned with is a final order made ex parte. The question is, should that
order
have...
made ex parte, which is then applied to be set aside, which isn't set aside, so all intents and purposes, it's like a final order of the court.
My lord, if we consider... well, it was a final order at the outset. I understand my lord's point,
Yes.
that it remains a final order. But if that order should have carried with it, when it was first made, if it carried with it implicitly an obligation to pay, then the fact that a subsequent request is made and refused can't affect what that order should have carried with it at the outset. If the liquidators were in breach of their obligations to the court to bring to their attention the requirement to give a cross-undertaking in damages or an obligation to pay the costs of compliance with a Norwich Pharmacal type order, and they failed to do so, and the order has been made, and it is something that is so obvious or is a requirement of the Norwich Pharmacal jurisdiction, it simply carries with it that order. And what another party says afterwards, please put this into the order, doesn't make any difference.
Well, it's not quite another party. It's the very party who's intended to be protected, turns up at once and has the opportunity to say what has to be said and what is to be said on his behalf.
Yes, but my lord, let's suppose that the party hadn't turned up at all and had simply complied with the order and then come back to the court.
Yeah, well, that's not what happened.
My lord, that isn't what happened, but any undertaking that was implied when the order was made is not discharged.
No, I can see if one's implied. I see the force.
And that's what we're dealing with, my lord. We're dealing with implied undertakings. And that's why...
But if there isn't, I mean, this is the whole question, whether there is an
exactly.
implied undertaking.
Yes.
My lord,
Or whether it should be express if it's to exist at all.
my lord, and that's why we're dealing with these implied undertaking cases.
But can an implied undertaking survive the express refusal of an order to protect you on costs?
My Lord, there's no it couldn't provide an express refusal, but there has been no express refusal.
Well, you didn't ask for the costs to be protected against the costs of complying with the order.
Sorry, my Lord, there was a
did,
request.
but
It was
there
ignored.
wasn't an order.
It was ignored.
Well, exactly. But if you ask for that order, it's a bit difficult to imply something which has the same effect of a specific order that the court's refused.
My Lord, the question is whether it was there already and whether it makes any difference. I understand the point.
It can't have been there after the inter-parties hearing. I mean, at that point, you have
say,
it.
why is that? I mean, if the judge simply failed to deal with it.
My Lord, if the judge says, you have asked me to deal with this question of cost, he could say one of three things. He could say, I don't need to because it's implicit. He could say, I do need to deal with it, and I'm actually making this order subject not to payment of costs. So insofar as it was implicit, I'm setting it aside. Or, as happens, he ignores it, and nothing happens. And the position there is that if there was an undertaking to pay, which was given, let's suppose, my Lord, that an express undertaking had been given, of course we wouldn't be in this position.
Quite.
But if the undertaking is implied as a matter of practice, to set aside that undertaking, to release the liquidator from the undertaking because you have asked and it hasn't been addressed, would not be just. To ask and have it refused would be, but to ask and have it ignored, we'd say, well, that's simply wrong. Not least if it was wrong in law.
So when we get to the Court of Appeal, what do you say about that?
My Lord, at the Court of Appeal stage, the costs had already been incurred.
I know they had, but why were you asking for an order that they be paid if you had the benefit of a cross-undertaking?
My Lord, we weren't asked for an order that they be paid in the Court of Appeal. We were asking for an order that the disclosure order be quashed so we didn't have to hand over the documents. And one of the grounds for that was that the order should never have been made because it didn't include a provision for the payment of costs.
Quite, but in your case it did.
My Lord, yes. If implicitly...
Right, that's why I'm saying...
I understand the Court of Appeal might have said we're not going to quash the order because implicitly it does include the payment of your costs, but they didn't.
I mean, effectively, your application to the Court of Appeal was they shouldn't have their cake and eat it. In other words, they shouldn't both have the benefit of seeing the documents and the benefit of not paying any costs.
Absolutely. The costs had already been incurred by that point.
But didn't you apply to the judge for extension of time and so on?
No, my Lord, we didn't. We applied to the judge to set aside the order. On that application, he extended time. He wasn't prepared to set it aside.
But surely one of the reasons why you applied to the judge there was, again, that you hadn't had an undertaking. Or am I wrong about that?
Well, that was one of the bases that we said.
Yes. So, I mean, you knew perfectly. Your argument now that the undertaking was implied is inconsistent with what you thought at the time.
What you said at the time.
And what you said at the time. I mean, first you asked at the original hearing, inter parties, I think we'll give up Latin, for such an undertaking. And then when you asked for it to be set aside and then an extension was given again, you did so on the basis that there was no undertaking.
Yes, my Lord, one has to understand the context in which those applications were before the learned judge, who was exercising, as he saw it, a 195 jurisdiction. And we have to look at that with the benefit of hindsight. And the benefit of hindsight, we see that jurisdiction simply wasn't there.
A number of authorities which are helpfully gathered together in Ms. Toombs' I think, final submissions, in written submissions, that cast doubt on the idea of a...
Oh, no, my Lord, they don't. They all support me.
Right.
Ms. Toombs' case, in a nutshell, I think, on this is this, that in England there was a practice which was made by the practice note in 1904.
That's right.
Following Howard. That practice note was never in England, never in Bermuda, and therefore there is no implied undertaking. Now, my Lord, Howard actually is authority for the contrary when it comes to undertakings. What Howard tells you, and if we go to Howard quickly, you'll see it very quickly, is that it's at bundle C, tab 3.
Thank you.
you'll see that this was a case where no injunction was granted, but an undertaking was given in lieu of an injunction. And the whole judgment of Lord Justice Vaughan Williams, sorry, one can say Mr. Justice Farwell said that the established practice, you'll see on the left-hand side, left-hand column, towards the bottom of page 558 of the bundle,
Yes.
Motion for interim injunction was never opened at all. What happened? The parties went out between themselves and the defendant gave an undertaking. Mr. Justice Farwell said, well, you don't have to ask for a cross-undertaking in damages when you get an injunction, and the same applies when the defendant gives an undertaking in lieu of an injunction. Lord Justice Vaughan Williams said there's a significant difference if you look at 559 column 1. An injunction is something that this court orders, something the court compels. With regard to an undertaking, I do not suppose anyone seriously suggests the court can by its order compel an undertaking. But nothing in Lord Justice Vaughan Williams' judgment says anything contrary to the practice on the grant of an injunction. It's dealing with the defendant giving an undertaking.
In that case, it was complicated by the fact that the order drawn up did record a cross-undertaking, didn't it?
My Lord,
Look at the towards the top of column 1 on page 719, 558.
yes, the question was whether it should have done,
Yes,
where none had been given.
yes.
And the point is it was done because the registrar essentially was told, on injunctions, put in a cross-undertaking in damages, as it's standard. And we then get to...
yes, but the point is that the parties knew from the moment that order was drawn up that the plaintiff knew that he was subject to a cross-undertaking.
No, but he wasn't.
No, there wasn't.
Well, then, because it was recorded in the order.
No, but that was the undertaking, not the cross. It said there should be a cross-undertaking to secure the undertaking. So
Yes,
to speak,
it was my Lord is confused. The defendant's undertaking
I see.
was in lieu of an injunction. That was recorded in the order. But Lord Justice Romer, if you look at the first column on page 560, you can see it, the second sentence down.
No, the order itself, I think, did record a cross-undertaking.
Yes, my Lord, but the defendant wasn't, the plaintiff wasn't liable on the cross-undertaking.
Yes, I
He'd
see.
never given it.
No, well, that was the issue. Yeah.
And my Lord, if my Lord will look at Lord Justice Romer,
Yep.
the first column on page 560, second sentence starting in the first place, my experience is that there's no general practice. Whenever on a motion for an injunction a defendant offers to give an undertaking, a corresponding undertaking as to damages on the part of the plaintiff is in fact to be implied. I know of no such practice. There is a practice, and a right practice, I have no doubt, that in cases where the court grants an injunction, it always makes a term, whether it's express or implied, the injunction granted on terms then undertaken by the plaintiff as to damages. And you can see it in Lord Justice Cousins Hardy at... in his judgment on the right-hand column. So, my Lord, the point about this case was that a cross-undertaking had been inserted in the order wrongly by the registrar in the case of an undertaking given in lieu of an injunction. This case says an undertaking in lieu of an injunction isn't the same as an injunction, so the usual implication on an injunction doesn't apply. That's why there was a practice note shortly afterwards, which you'll find at the next tab, at 565. And the practice note that my learned friend says doesn't apply in Bermuda, and that's the answer to this point. If you look at that, it's on the far right bottom corner of 565. Mr. Justice Kekewich issues the practice note on December the 9th. The judges of the Chancery Division have had under their consideration the practice as to an undertaking in damages where an undertaking is given in lieu of an injunction. And they have resolved that in future, an undertaking in damages will follow as a matter of course without being mentioned wherever there's an undertaking given in lieu of an injunction. My Lords, the practice in respect of an injunction was well established and was clear. Howard was distinguishing that practice from an undertaking given in lieu of an injunction. The practice direction recorded in the weekly notes pulled back the position on an undertaking in lieu of an injunction to match the position that was already outstanding in respect of an injunction. And that's why my learned friend's point fails, because the practice direction not applying in Bermuda is irrelevant to our case. We didn't give any undertaking to comply with the order. We were under a mandatory injunction to do so. And therefore, the usual practice pertained.
Yes, but this is concerned with an interlocutory injunction, not a final order, isn't it?
My Lord, this is concerned with an interlocutory injunction. Yeah. So we start there. But if we're talking about implications, then the point that there is no implication in Bermuda, even though there's an implication in England, because the practice note doesn't run in Bermuda, which is my learned friend's point in her written submission, falls away. The practice note is irrelevant to an injunction.
I understand that, but this is concerned with interlocutory injunctions pending final trial.
My Lord, that's right. And that's why if the analysis of this is that it is an ex parte injunction and a cross undertaking in damages, that's where we say on the giving of that on the grant of that injunction, the undertaking was implicit, the cross undertaking was implicit. It was there because it was an ex parte application. If that's not the right analysis and we look at the Norwich Pharmacal analysis, we then simply say, does the same position arise on a Norwich Pharmacal jurisdiction where it's quite clear that the price for your order is that you have to pay for the third party to comply?
Well, it's not, is it?
I thought Mr. Justice Hoffman.
Yes, quite. I mean, it's inconsistent with your fallback position, which is that you wait until the end.
No, my Lord, that, with respect, that's if we go down my learned friend's 236 analogy. We can't do that for Singularis.
So Norwich. So there are interlocutory injunctions. There's a position there. There is Norwich Pharmacal when you're seeking a disclosure order, disclosure of information or documents. And then there's the insolvency type situation dealt with enabling Bath and PCI. And they're all different.
They're all different. And this was, if we look at Singularis, look at SAAD, I understand my learned friend's 236 analogy, because there was a winding up order and there was section 195 of the Act, which is equivalent. There we say, all right, if that's the correct analogy, this court, or if not this court, although we say it should be this court, the court at first instance, has a discretion to make an order in the usual way. But we say this court can do it because the public interest has fallen away, as is obvious. So far as Singularis is concerned, either you look at it on the basis of an ex parte injunction obtained, or you look at it on the basis we say is the better basis, and this is the basis which my Lords, Lord Manson, Lord Sumption, I think, alluded to in the main judgment, and frankly one's gut feel for it. This is like a Norwich Pharmacals case. There is no statutory basis for ordering the disclosure of documents. Therefore, it must have been done on a Norwich Pharmacals type basis. If it was done on a Norwich Pharmacals type basis, that comes with the implied obligation to pay. It doesn't have to be expressed because it's there anyway.
And what's the authority for that?
Norwich Pharmacals.
Norwich Pharmacal itself.
Well, Norwich Pharmacals says that's the price you pay.
It's the one case we don't have, do we?
No, my Lord, we do have.
We do have it. Where do we have it?
We have referred to it in our submission.
Oh, yes, we do. It is, sorry, B15 here.
Yes, we have referred to it in our submission, my Lord. We've referred to the...
Yeah, where is it?
B15.
15. And where do they deal with costs?
My Lord, they deal with it at Lord Reed. I'm not sure these are the full references, but Lord Reed certainly addresses it at 411C.
It may be, if this causes him expense, the person seeking the information ought to reimburse it.
Yes, but one has to see the context in which that was, the way that was being put.
Well, yes.
It's a question of the context. But if one looks at Lord Cross at 435, at G, My Lord, I'm afraid it's in our written submission that we had addressed this. This is a Bundle B case, so it's one that was referred to in our written submission.
Yes.
Is it the practice in Norwich Pharmacal cases for the internal hourly rates to be indemnified?
My Lord, so far as that goes, I couldn't say. We, on this application, have agreed between the parties that questions of cost, rates and quantum shouldn't be dealt with at this hearing. We shouldn't be dealing with the principle. If, of course, we get to the stage that we're looking at the actual costs, those will have to be addressed in some way.
But I'm only asking the principle of it, not the quantum. In principle, in Norwich Pharmacal cases, can, for example, an accountant who is asked to produce documents, or a bank that's asked to produce documents, is it able to charge its officers' time on an hourly basis, even though it isn't actually incurring it?
My Lord, I'm not in a position to answer that question. I hesitate to answer that question without having looked into quantum issues further.
It's not an issue of quantum, it's a question.
I understand it's a point of principle, but not having been concerned with quantum, it's not something that I would feel comfortable answering as a matter of principle. What I would say is that as a matter of principle, the costs, the internal costs, could be recovered. The rate at which those costs would be charged would be a matter to be assessed.
Because nowadays, it is possible to recover, for example, in-house legal costs of a client.
And one of the points I think that we had made was that many of the costs that had been incurred here had been incurred in-house because it's a professional client.
Yes.
Whereas another person might have gone to their solicitors and said, help me with this disclosure process.
Yes.
You show me which is privileged, which is confidential, and so on. Because there is an in-house team with a professional client, they're able to take a lot of that burden.
Yes.
And so, clearly, if they would have been recoverable had they been legal costs, it would certainly be a ground for saying that they might, as a matter of discretion, be recoverable if they're internal costs.
In Mr. Justice Weinlott's case, he was shocked by the fact that the hourly rate was £35 an hour, and that as
yes.
much as 500 hours might be spent.
Yes. So
Where is the reference to this in your submission?
the reference in my submission. We refer to the Norwich Pharmacal basis at page 10, Bundle A, page 10. We also refer to Miller Brewing Company in the footnote at 5. Disclosure orders against third parties, which is another parallel. And my Lord Neuberger's comments in Miller, we've set out in the footnote at footnote 5.
Yeah.
So that's how we've addressed it, my Lord. But, my Lord, the points that I think my learned friend had sought to make on the basis of the implied undertaking and damages, when you look at it, none of those touch on the question of implication of cross-undertaking where there is an injunction.
Yes, I see.
Rule off that point. They all deal with other third parties coming in to take the benefit of a cross-undertaking damages or undertakings. None of them touch on the main principle. If that's the case, we've referred to, and I need to refer you to it now, Mr. Justice
Laddie's decision, yeah.
His decision.
So your point is that there is a standard rule that you imply a cross-undertaking in damages where a claimant, plaintiff as it was, gets an interlocutory injunction you imply that he gives a cross-undertaking in damages to the defendant against whom he's got the order.
Yes.
All the other cases are concerned with third parties that Ms. Tube relies.
They're concerned with third parties, or they're concerned with undertakings. And therefore,
Or with undertakings, quite right.
or undertakings. And therefore, firstly, Mr. G's book, approved by Laddie, the 4th edition, is correct. Smith-Klein Beecham doesn't
Yes.
actually doubt any of that at all. And there is in Mr. G's 5th edition, which is at tab 20 of Bundle B, another basis of looking at this, which is the obligation of any person on an ex parte application.
Now, are Section 236 applications in this in England and Wales normally made ex parte or not?
My Lord, they used to be. I don't believe they are to the same extent today. They used to be.
And were they normally recorded?
But I don't think anyone would make an ex parte 236 these days.
And when people made 236 applications and they were granted, were the orders drawn up? Did they include a cross-undertaking in damages?
My Lord, no.
Because of the public interest point.
Because of the public interest point. So that would necessarily be a matter of discretion for the court to deal with at a later time.
And Norwich Pharmacal orders, what do they, how are they drafted?
My Lord, I don't have a standard on my own from.
Very well, don't worry, thank you.
My Lord, that's it. My Lord, our final point I'll deal with quickly is the ex parte James point.
Yes.
In other words, let's assume that no undertaking was given. Let's assume that the learned...
Let's assume all your arguments today fail, yeah.
They all fail. What then? Well, we've seen that we're dealing with joint official liquidators in the case of SAAD.
Yes.
Not Singularis, but these were officers of the court. They're officers of the Bermuda court. And if there's a general obligation on a litigant, an ex parte application, there's a greater and continuing obligation on an officer of the court. And my Lord, see the way that the principle is expressed. We're not relying on ex parte James, the ratio. We're relying on the principle behind ex parte James. You'll see that expressed in multi-guarantee at B14, 336 to 367. Notes. It was well expressed by Mr. Justice Templeman, Wive and Development, which is at B tab 18. Passage there. And the expression at page 532 of the bundle, commenting on Williams and bankruptcy, the rule in ex parte James, the trustee ordered officer of the court to do the fullest equity, certain case even higher standard of conduct, not easy to define the exact bounds, based upon the control exercised by the court over its officer, and that, my lords, is the key, which, since it operates in a field not covered by the established rules of law and equity, is incapable of reduction to an exact formula, must in its application be governed in part by ethical consideration. So we're looking at what should have been done, even if it wasn't actually done. And this is a case where the principle was actually extended. You can see that at F to G. My judgment, in these extreme circumstances, I see no reason why ex parte James shouldn't apply or be extended if necessary to allow the official receiver to comply with an express promise made by him in the circumstance in which he was placed. Well, we say it should be extended or applied here to apply to an express promise that should have been made, even if it wasn't. So if the JOLs didn't raise with the court this question, if they proceeded at risk, then they should be treated as if they had made the promise, as if they had given the undertaking.
Yes, I see.
And the court won't allow its own officer, by his own neglect, to be an instrument of injustice. And finally...
Is this, I mean, that these liquidators are not the officers of the jurisdiction of the court in the jurisdiction from which this appeal comes?
My lords, the liquidators, there are 3 joint official liquidators in Cayman, right, who were all appointed joint official liquidators in Bermuda, together with one local individual, Mr. McKenna, who was applied to give some local colour to the liquidation.
I follow.
So they are the same people. The final point, if I may, my lord, if I can just, as if I can put it, the after-dinner mint, could I hand up a case which...
This only goes to SAAD, does it, as liquidators of SAAD?
This goes to SAAD, yes, my lord. The liquidators sought recognition in Singularis, but I don't think I can say that they should be treated as officers of the court. Could I just hand up this case? It's one that arose, it was referred to in the very wide-ranging analysis in National Australia Bank and Bond Brewing Holdings, my learned friend's case, which says, essentially, if you don't have an undertaking or something else, you can't, even if it's unfair, you can't require payment of damages caused by an order wrongly made. But this was referred to as an exception to the case on the basis, it was thought in the Australian case, that here was a situation where there was an officer of the court involved. So what had happened very briefly was that a solicitor obtained an injunction. The solicitor was himself seeking to bankrupt the plaintiff.
Yeah.
The solicitor failed to mention that to the court. The plaintiff gave the cross-undertaking in damages. That was worthless, and the court said the solicitor should pay the damages. So it's an example of the court exercising a jurisdiction over its own officer, where that person should have brought something to the attention of the court but failed to do so. So we say, well, similarly here, if the JOLs, my lords say, these JOLs ought to have given an undertaking to pay these costs.
Yes.
They didn't, and therefore we can't make them pay the costs.
We have the point.
If they should have done, the court has the power to require the liquidators in SAAD to act as if they did.
Yep.
Because they're officers of the court and they're within the power, my lords. Unless I can assist you further, those are the solutions.
Thank you very much indeed, Mr. Chairman. Thank you. Ms. Two.
As your lordships are aware, we're not dealing with the question of legal costs here. We're dealing with the question of costs of compliance. And really what PwC is seeking are damages in relation to an order that has been set aside and has been reversed. I'm not dealing here with their 236 after the event argument. I'll come back to that later. But all the rest of their arguments say, effectively, the Court of Appeal shouldn't have made the order that they made, neither should the first instance Supreme Court, and we ran up costs and you should pay them. And a lot of this boils down to a submission that it isn't very fair that they should have to run up costs.
Well, to an ordinary observer from outside, there's considerable force in that, isn't there?
And I can see how, as a matter of sort of general
You've got an order which they objected to and fought against you getting. You've added insult to injury by making them do things pursuant to the order, and now you won't pay them the cost of doing so. Not very attractive.
And I can see that, but we know that in fact one doesn't get damages which flow from orders which are set aside. You can, in certain limited cases, get restitution of monies paid or benefits passed, but this is not one of those cases. They have spent money, they say, putting together these documents which they haven't given us. We have to remember that the one thing that we know has not happened is the estate has not benefited in any way because we haven't received these documents.
There's no sort of, as it were, quasi-restitution.
There's nothing here on that.
But they've nonetheless spent money they didn't want to spend, you've made them spend, and they're not going to pay them. Yep.
Well, we asked the court, and the court made them spend. And I think that is an essential difference, because that's why what they're seeking are damages which come from an order that's been reversed. And as it was put in the Bond case, which I'm going to take your lordships to in a minute, which is the very helpful Australian, incredibly lengthy, I won't take you through all of it, but it is, as it was described in SmithKline-Beecham, as a masterful analysis of why it is what they're saying isn't right. You can't just say, well, it's not fair, it doesn't seem very equitable. You have to have some basis for getting recovery.
Well, to be fair, Mr. Chivers has put forward a number of bases.
Well,
he hasn't concentrated on the fairness.
No, that's true. But when one looks at the implied undertaking points, that really is an argument that, well, you should have given this undertaking at the time, you didn't, and therefore we should ex post facto imply it. He can't go as far as to say there is any settled rule that an undertaking should be given like this, because there isn't one. At most, as the cases that he's shown your lordships say, the court retains a discretion in exceptional cases to order costs of compliance. And I accept that in the two cases in which the court has actually considered this, the two reported cases, it says, well, we'll consider it after those costs have been incurred. So it's a bit hard to see how that can be any implication, there can be any basis for an implication that one would give an undertaking at the start that if the order was set aside, we will pay, but if the order remains, the court has a discretion to see whether you will or won't pay. That's a little of a wishy-washy way to...
Is that submission confined to the insolvency situation? Because the two cases were both insolvency cases where the liquidator, administrator, or whatever was relying on particular statutory provisions.
Well, what we say is that you actually start from the other end of it. So your first point is that you don't generally have a cause of action for reversed judgments. Your second point is that generally the only way that you can get your damages for judgments that are set aside is in relation to either benefits that have passed, but let's just put those restitution points on one side, or if an undertaking has been given. That's why one gives an undertaking, because in the absence of an undertaking, there isn't a basis for claiming those damages. And the cases make that very clear, including the bond case.
Just help us. Undertaking, very familiar in the injunction type situation, but what's the position in relation to Norwich Pharmacal, where you have an order for disclosure of information or documents?
Well, the exception to this rule that one does not generally write things into the order after the event is where there is a settled law of or practice that those costs should be paid. So Norwich Pharmacal is a settled practice where the costs of compliance are to be paid.
But that's usually written into the order,
yes,
isn't it? I mean,
it is. Yes.
But it's not that's not done by way of requiring an undertaking from the person seeking an order, is it?
No, it would normally be just a term of the order.
Just a term. I suppose really it's understood in the sense that the order wouldn't be made unless that term was accepted by the person applying.
Yes, although you have to be slightly careful on that, because one of the things that happens, and one of the things the cases make clear, is that if the court asks you to give an undertaking and you say no...
Yes, you don't get the order.
Well, you may not get the order. You probably wouldn't get the order. Yes. But it's not that the court somehow implies it in there or can compel you to do it. So those sorts of cross-undertakings, because they're voluntary, they can't be compelled, and the court can't order them retrospectively. And we see that both from the Bond case and from SmithKline-Beecham, which is dealing with third-party costs. The court can order that third parties' costs or third-party damages are covered. Those sort of, I say order, obtain an undertaking that they'll be covered. And in SmithKline-Beecham, there could have been an undertaking that third parties would be protected, but there wasn't. And in the absence of that, in SmithKline-Beecham, what we know is that those costs are not caught. And so where you have a general rule which says you can't recover these unless there's a settled rule that says something else. So Norwich Pharmacal is an example. But the one thing we know about this case, and you, my Lord, Lord Mance, made it very clear, is that this is not a Norwich Pharmacal case. And I think it's worth just for a moment looking at how your Lordship put it in Bundle B at tab 16, page 493.
This is a dissenting judgment, isn't it?
It is, but...
well, I said exactly the same.
I think, as your Lordships may recall, nobody suggested this was anything like Norwich Pharmacal. No. Until I think in the course of argument it was suggested that maybe we might be able to get an order if it was like Norwich Pharmacal.
Well, the point made in my judgment was that it wasn't a Norwich Pharmacal case, but that Norwich Pharmacal provided analogies when it came to the question whether such a remedy should be developed.
Yes, and that's a question of whether or not it exists as a matter of common law. But that doesn't mean that this is like Norwich Pharmacal. No, indeed. I mean, I said in terms, this is not a Norwich Pharmacal case. No. Absolutely right. And my Lord Mance said, quite rightly in paragraph 129 that there was a deep dividing line between the basis on which we put our case and Norwich Pharmacal. And your Lordship pointed out that the insolvency regime goes much wider than Norwich Pharmacal. And it might be worth just stepping back for a moment to the basis for all of this. And this is, informs, I think, the way that Mr. Justice Hoffman put it in the J.T. Rhodes case, and for that matter in Avening Barford, which is this is a case where a liquidator comes into a company, he's a stranger to the company, he doesn't know anything at all about it, and needs to get information in relation to it. That's what 236.195, the common law right. What all of those do is entitle a liquidator to obtain information from those people who have it in circumstances where he's a stranger. But that's not a question about innocent people being mixed up in a fraud. It's a question about the public duty of people to assist in conducting insolvencies. And so that's why it's a very, very different thing. So there just isn't anything, whether by way of implication or, for that matter, breach of an officeholder's duty to seek some sort of cross-undertaking, or give some sort of cross-undertaking in relation to cost. There is nothing in an insolvency context, because in fact the principle in insolvency is that you don't pay these costs. The costs of compliance are not generally paid. They don't appear in a normal 236 order, and people who ask for them usually don't get them. It's a very exceptional case where people get them ordered. Now, my learned friend effectively says in relation to that, well, this is a very exceptional case because it was a lot of money and this was a jurisdiction that should not have been exercised. And we say, but we did not get the documents. What he's seeking is an order that the creditors of this estate bear the costs for work that they've done in producing documents which we don't have.
Is there any reason why he shouldn't seek now an order at first instance, at least in the SAAD case along these lines, and where your side would be able to make that same point?
Yes, we could. Although,
is there any reason why he shouldn't?
Well,
is there a jurisdiction to do so?
Well, the order's, of course, been set aside, and the Court of Appeal was asked, well, my learned friend said they weren't actually asked to make this order, but the Court of Appeal has said that they won't make this order. So I'm not sure how, at first instance, the judge will respond to circumstances where the Court of Appeal has already said no.
Do we have jurisdiction to make an order under Section 195 today, or in due course in his favour or not? Are you saying we don't have jurisdiction or we shouldn't exercise the jurisdiction?
I say you shouldn't exercise it.
So you concede we have jurisdiction?
No, only for SAAD,
Yes.
not Singularis.
Because even though we've set aside the order was made under the section, and it's unrealistic
Yes.
for you to say we have.
I think so, and I don't think any of us really want to spend more money arguing it somewhere else, if I can put it that way. But only in relation to SAAD.
Yes, I understand that.
But do we have the material on which to, assuming that we did decide to exercise that jurisdiction, have we got the material on which to form a view?
What about the amount of it?
Well,
in principle, not on quantum, obviously.
yes.
Yeah.
Yes. I can't imagine, because there's all sorts of material on quantum,
Yeah.
but the jurisdiction, it must just be the principle. So they say that we asked the court to order them to do the work, and that the court did not stay until after they'd done the work that they'd done, and they say they've done it.
And pursuing the question of jurisdiction for a moment, I mean, obviously there's an important difference between SAAD and Singularis, but in the Singularis case, the common law power, at least two of the judgments indicated that any such common law power would have to involve the payment of costs. I know you challenge the correctness of that, but are you saying, you challenge the correctness of it essentially on the public interest point, didn't you?
Yes.
That there's no analogy with the Section 236 cases. But do you say that there is no jurisdiction to exercise the common law, to direct the payment of costs of compliance with the common law power, assuming that the decision had, assuming that because we held that the decision, that the jurisdiction to make the order existed but wasn't exercisable in this case. Suppose it had been exercisable, suppose there hadn't been the problem about the difference between the powers of the Bermudan and Cayman liquidation. Would there be jurisdiction to
well, the way that
costs?
the way that the jurisdiction, of course, is put here in this country is that there is a rule which provides that the costs of witnesses can be paid, and therefore, by extension from that, the costs of producing documents can be paid in theory.
Yes.
And then that there is no, obviously, as in common law, there's no such rule, but it would be difficult, I think, to contend that the court is not allowed, as a matter of common law, to common law assistance, to provide conditions on which that assistance can be given.
Well, manifestly, Norwich Pharmacal was a case in which a common law power
Yes.
was adopted by the House of Lords.
Yes.
And on exactly that footing.
Yes, I don't think that's a submission I can make, that there's no jurisdiction to make.
If a jurisdiction exists, do you say that there's no jurisdiction to exercise it at the end as opposed to the beginning?
No, and that I think I said, Mr. Chivers is right on that point, that what we say in relation to that is that the question of whether costs of compliance should be paid should be raised at the hearing with the judge, as it always is.
But if the judge then says...
We'll decide it at the end.
Then it's decided. But if you
That's
don't
right.
raise it, or the court says, we're not going to give you your costs, that's that.
Well, that's right. So that's, I think, the difference between them. So I don't think, I think it is wrong, the way in which we put it was a little bit too firm. But the point is that it has been decided that those costs should not be met.
But why can't we treat this as an appeal against that particular finding?
Well, Malone Friend says there was never any finding of that in the Court of Appeal.
Well, there wasn't there?
Well,
I know that's what he says, but the Court of Appeal seems to have thought there wasn't power to make the order. Or it's never been done before.
no, I think what it said was that Mr. Chivers hadn't provided any authority which suggested that the costs of compliance should be paid.
I mean, he seems to think that the way, at page 82 of Bundle A, in the absence of authority, I'd not make an order. The joint liquidators either be responsible for or give an undertaking in relation to the cost of compliance.
Yes, of course
But
they haven't.
He treated himself as being asked to make an order.
They did, but Malone Friend, I think, repeatedly said this morning that wasn't an order they were asked to make. So I think he's disavowing an appeal on that basis. He hasn't made an appeal on that, brought an appeal on that basis.
No.
And I think today he wasn't making an appeal on that basis.
Not quite clear to me why not.
Well,
It's never too late, Bromley.
If you accept that both under the statutory power purportedly exercised in SAAD and at common law, there is a jurisdiction to direct the payment of costs, and a jurisdiction which I accept you say shouldn't be exercised to do so at the end rather than the beginning, presumably that applies a fortiori to a case in which the order should never have been made, because the principal difference between those situations is that as a matter of discretion there may be a strong public interest reasons for not directing the payment of costs when the order should have been made, whereas on the face of it there's no public interest if the order should not have been made.
I think the position is that when you're looking at the costs of compliance, you're looking at the costs of compliance for an order that should have been made.
Well, yes, but I mean, why isn't the case where it shouldn't have been made an a fortiori case? They complied with it on the footing that the order stood until set aside.
But then
subsequently, it is held that it should never have been made, but it was nevertheless the cost of complying with an order which was valid until set aside. And when it was set aside, it became impossible to argue that as a matter of discretion, the public interest required it to be done for free.
Because then what you're asking for is damages in relation to an order that's been reversed.
Well, I agree that in this rather special context it's no different from that, although juridically I think that that it is rather different. I mean, once you acknowledge that there's a discretion to do this, essentially your reason for saying that discretion shouldn't be exercised, and I entirely see the force of this, is that the problem about doing it at the end of the day rather than the beginning is that it deprives the liquidators of the right to choose whether enforcing or getting this order is worth the candle. And I can see that that is a discretionary factor of some force, but that's really the reason why, the order having been set aside, the discretion shouldn't be exercised, isn't it?
But you're, in that case, you're saying, here's an order which I've got, and let's assume for a minute that the reason why costs orders are often not made until the last event is because if you write a blank cheque to a respondent for a 236, they might spend more money putting together the papers than they would otherwise do.
Well, that's one of the reasons, but it may also be that as a matter of justice to liquidators who assume quite extensive personal obligations and so on, that it ought to be done at the beginning if there is any question of the liquidator possibly not wishing to go ahead on that footing.
Yes, and I can see that, although, of course, you might want to look at the way in the sort of documents that are produced, and for that matter, whether or not the person who has produced them actually turns out, and I use this not in a Norwich Falmacol sort of sense, but to have been more mixed up in it than they were.
Well, there are a variety of discretionary factors.
Of course.
And we don't know and never will know what the answer to the question that you've just raised is.
Yes.
But we do know that the retrospective imposition of a liability for costs would deprive the liquidators of a choice that they would have been in a position to make had the point been taken at the outset.
Yes, I see that. I see that. So that what effectively is being said is, well, we take this, we take out an order, it carries with it, let's assume on this basis and not on the implied undertaking, a possible discretion to be exercised at the end in circumstances where what we get is nothing. That is, taking us back to where we started, really an application for damages flowing from an order which shouldn't have been made.
Did the liquidators ever suggest they wouldn't be in funds to...
No.
I see. There's no problem about that.
No. And I think it's accepted that the liquidators in this case, which is of course not the case in many other cases, it's not a question of them being personally liable. They'll pay it from the assets that they have.
The possibly merits, if not legally proper, suggestion that the liquidators might provide you with what information they've obtained in return for you paying them won't wash, because presumably that would be a breach of their duties to all sorts of people, because they would be giving you information which they weren't obliged to give you as a matter of law.
Well, if it was confidential information, that
Exactly,
might be the case.
if it's confidential. It
But
isn't available anywhere else.
Whether it's confidential to the company might be...
I also think Your Lordship may have it the wrong way
So
round.
Absolutely, I have it the wrong way round. If
PwC gave us the
PwC
information, yes.
Could we order it as a condition of payment by the liquidator?
Well, in that case, Your Lordship's having said that there is no basis for it to be made under an insolvency, it would, I assume, just be a contractual basis.
Well, it would be saying if they want the money. If we're attracted to the argument that you are not getting any benefit from this, it would be a way of answering that, but it may be wholly inappropriate. I don't know. What do you
mean, generally, in the context of a 236 order, the confidentiality and privilege points sort of fall away.
But we said 236 doesn't apply.
Well, quite. I understand that.
Yeah. Okay.
It is. So.
That's your list for you, really.
I'm not going to make that point.
So one comes back to Lord Thompson's point that if there is a power to order it, and you accept there is under 236 or common law, then it might be said against you, as Mr. Chivers has said. It's hard to think of a stronger case for saying it should be ordered than when you've obtained such an order, they've had to do the work, and now they're saying you shouldn't have got the order in the first place.
Well, I'm not sure I see why that's a stronger case than where they've done the work and we have got the documents.
No, from their point of view, they're adding insult to injury. They've
Well,
had to do the work and they weren't even obliged to it.
But that is taking us back to it's not fair that you got an order against us, and we've suffered damage in relation to it.
Well, yes, but if we're into discretion, then not fair does come into the picture.
Well, yes, but only in the question, when one exercises that discretion, you exercise it in the context of with an insolvency hat on.
But this is a rather special context. I mean, you're absolutely entitled to say that the effect of our directing the payment of the costs would be similar to that of awarding damages for the impropriety of the order. But the particular basis on which that would be done is that the work was done pursuant to an order which carries with it a discretion, if necessary in arrears, to direct the payment of the costs. Now that's a completely different situation to the situation which arises where an ordinary order is made by the court, which is subsequently set aside.
That's right, but in this case, what you would be saying would be you have a liquidator, as your lordship put it earlier, the liquidator is effectively on risk for the costs that are being run up in relation to it, which he doesn't find out about later.
That's a discretionary point which I acknowledge has some force. I'm simply demurring to your suggestion that this would be objectionable for the same reason as it would be objectionable to award damages for the making of an order that shouldn't be made. Because in this particular context, what you're actually doing is giving effect to a discretion whose existence is inherent in the making of this particular kind of order. It's not a general acceptance of the proposition that damages can be awarded for the making of an order that shouldn't have been made.
That's right, but as part of the discretion, you're saying, or PwC are arguing, that where you make an order that shouldn't have been made, that weighs very, very heavily in the discretion on their side. And I say, well, bearing in mind one does not normally get damages for an order that shouldn't have been made, it would be odd if that was the determinative point.
Well, the reason why the fact that it shouldn't have been made adds something in the scales when you look at the discretion is that if the order ought to have been made, the main argument about the exercise of discretion would be whether the work shouldn't be done free because it's in the public interest.
Yes.
That's not an argument which can arise if the order should never have been made.
Well, it depends what the public interest is. If the public interest is that liquidators should have assistance in being enabled to work out what the assets of the company are, that public interest remains the same. We just haven't got those documents.
Well, no, it goes further than that, because they were under no obligation, in the public interest or otherwise, to supply this information, and that's why...
No public interest in the relevant jurisdiction, because you didn't have a status there to seek it.
Well, we did in the context of SAAD.
Well, you did for a time, you're quite right.
Yes, until it was set aside on the ground that there was no jurisdiction to do it. So the same point arises in both cases.
Yes.
Well, that's part of the problem, because it assumes that things exist which no longer exist. But on both sides, because what Malone and Friend says is, well, this discretion still exists because you were there with your office holder hat on. I mean, there's no question but that as a matter of common law, your lordships have found what you found about not being able to obtain common law assistance because we didn't have the power back in Cayman. But as a matter of common law, the order that we were seeking was an order for provision of information which was in the public interest for people to give us because we were the liquidator.
Well, so you wrongly thought.
Would you have been able to? Well, you wouldn't have been. There wouldn't have been couldn't have been an appeal from paragraph 63 unless there'd been a stay, could there? There couldn't have been an effective appeal.
Your Lordships may recall that, in fact, an application was made to this court for a stay, and that was granted. But their argument is we've done all the work by then.
Was the work done by PwC between the Supreme Court and the Court of Appeal, or between the Court of Appeal and the Privy Council?
I think between the Supreme Court and the Court
That's what I thought. Oh, I see. Was a stay, so really the Court of Appeal was dealing with matters after the event, as we are.
Yes. Yeah.
Now, that's I thought. Now, so far as the Supreme Court was concerned, there was an application for a stay? Was there? On doing the work or not? What happened?
Do you know if there was? Mr. Chewers may be able to...
Well, in the Supreme Court, there was no application for a stay. The Supreme Court extended time for compliance, which allowed the appeal to take place within that window for compliance.
That's what you said, yeah.
And the compliance continued both before and after the Court of Appeal hearing.
So basically, there was discussion about what should be done, and of modus vivendi was effectively agreed in court, or the judge just imposed it?
The judge imposed it, my lord. The application was to set aside the order. The then judge, having seen the evidence as to the time it would take to comply, said, well, I will give you this time for compliance that you have said you need to comply, and that will also allow time to appeal in the meantime. But he didn't grant any stay at any stage.
So there was no formal application for a stay and no opposition to a stay, a fortiori?
A fortiori.
Thank you. Sorry, Ms. Toop, thank you.
No, not at all, my lord.
Thank you, Mr. Chewers.
So, I think that where we were really concentrating on the insolvency end of the spectrum.
Yes.
And in relation to that, your Lordships, I think, have seen the relevant authorities and why it is that we say that there is not a general principle that these costs should be paid. And the reason why that's important is because we say it feeds back into the argument that my learned friend was making about implying terms, or for that matter, his ex parte James application.
Yes.
Because all of that depends on there being some sort of settled rule of practice that we will always pay, and even more so, some sort of settled rule of practice that we will always pay if the order is set aside. So not only if it's made, but also if it's set aside. And there's no settled law of practice on either of those. At most, what there is a discretion. And so
I suppose the position might be different if one was dealing with an order obtained ex parte which had to be complied with immediately before it could be set aside. Then you might say that justice should require, the court should have required some undertaking to protect in respect of that short period. But we're essentially dealing with the inter-parties situation.
Yes, and even that, I think, that the cases are quite clear that, including some of the ones that are relied on in G, that where an ex parte application was made and the cross undertakings were not given, what one does in the context of an injunction, which is the context in which my learned friend brought this all up, but which is not actually the context that we're in today. But in that context, the court will simply discharge the injunction. And again, the question would then become, are you entitled to damages flowing from an order that should not have been made? And then we are back into that whole argument again.
Yes, the argument where you say no, the cases, including the one referred to this morning, show that you don't imply undertakings, unless there's something like there is under the English rules
yes.
since 1904.
And so one example of that, for example, is in the context of injunctions, interlocutory injunctions under Part 25 of the White Book, the CPR Part 25, where it makes it absolutely clear in paragraph 5.1 of the practice direction that wherever you have an injunction, you have automatically a cross undertaking in damages unless otherwise is ordered. Well, that's a settled law or practice we wouldn't have much to say about that. And in that context, it's probably the case that although we have some issues in relation to the way that it's put, Mr. Justice Laddie's case is probably right.
What happens in practice? I mean, if the injunction is granted, is the order drawn up with the cross-undertaking included, even if nothing's said about it?
Yes, because it would be a standard form.
And that's what I thought.
And if it wasn't, it would be slip rule.
Yes.
And that would be a real slip rule
Yes,
case.
it would. So in practice, if the court decides not to impose a cross-undertaking, for instance, it involves the Crown, where the court normally doesn't, but sometimes does, there wouldn't normally be a record of the court not imposing. It simply wouldn't be there.
Well, not in the order, but there no doubt would be something in a judgment.
Oh, yeah, but it wouldn't be in the order.
No, it wouldn't.
So,
So
the way the rule is given effect to is it's automatically included in the order.
Yes.
And if it's omitted, then you correct it under the slip rule.
Yes, and actually it's nothing to do with implying undertakings at all. It's actually an express undertaking that's
Right.
automatically included.
That's exactly the point.
And so that's why this is not that kind of case at all, and all of that is really a red herring. And insofar as either G or Mr. Justice Laddie in the case that Milena Friend was referring to goes wider than that, it's just not correct. It's not that one automatically implies undertakings, because undertakings are things that are voluntarily given. They can't be extracted by the court at the time, still less retrospectively. And if you breach them, the remedies are contempt. And so all of that is irrelevant, we say, and in any event wrong. And I'm not going to repeat the points we made in our submissions about why those cases are to do with completely different things, except to make one point, which is Milena Friend, Mr. Chivers is right that the practice note is dealing with undertakings, which are cross-undertakings to undertakings on the other side. So in other words, if there's an undertaking in relation to frozen assets, a cross-undertaking, that comes from the practice direction. But as I've said to your Lordship, the way that it's now put in relation to injunctions is the Part 25 point. So that's that. In relation to bond, I think now I probably shouldn't take your Lordships to it, and I'm not sure it's going to be particularly relevant to the way that this is going to develop. But if I could just give your Lordship some page number references to bond, because it is such a lengthy case. It's at
Tab 8, isn't it?
Yes, Bundle C, Tab 8.
Yep. Thank you.
And your Lordships will have seen in relation to this case that it was a case about the making of an absolutely hopeless receivership order. It's an order that should never have been made. It was an order where the judge thought effectively he was making some sort of insolvency order instead of a receivership order, and it was flawed on many bases. And the first part of the judgment really deals with most of that. For present purposes, the relevant points are in the head note at page 659 of the bundle, number 8. This is the no damages if there's no undertaking.
Right.
What kind of receivership order was it made? Under a mortgage or?
Well, it was a charge.
Yes. Yeah.
It's under security. Yes, but theoretically speaking, it was under a charge.
Yeah.
But it wasn't a court-appointed receivership. No. But it was very confused. The judge didn't really understand what it was that he was doing at all. Page 828.
Yes.
Some days to get confused.
Yes. Yep.
This has some numbering down the line 45, referring to the English practice, which is the automatic inclusion of undertakings. 829, your Lordships will see that no undertaking was given and that it could not be implied. And just to, for your Lordship's note again, this was an order obtained ex parte.
Right.
And the court was very firm on this, that the counsel on that case should have drawn the attention of the court to the fact that no undertaking was given. And even in those circumstances, it then didn't imply any undertakings or anything else. Page 830, this is at line 12, the absence of an undertaking can be a ground for discharging an injunction where it's caused loss but not where it hasn't. And here again the court was concerned at line 30, the applicant should have given an undertaking at the next hearing and didn't do so. 831, down to at the bottom of the page, the judge was in serious error by not obtaining any injunction, obtaining any undertaking.
Yep.
And that it was complained about at the time and he still didn't give one. 832, line 5, the judge is criticised for completely misunderstanding the order he was making. And then 835.
I mean, do we really need to go through all these errors of the judge in this particular case?
We don't, but I think it's important for the background, which is the court thought this was an absolutely hopeless case.
Okay, well, we have that.
Okay, so then moving on to page 840. This is now, not surprisingly, buoyed up by that. An application was made, and your lordships will see under the heading damages that the companies sought an order that their damages should be paid, and that's what the rest of the judgment is about. And you'll see in particular the reference to Roger, just above where it says 45.
Which page?
Page 840.
Thank you. Oh, that is so, yes. Yes, Rod, that's right, yes.
Yes, and the submissions that were being made, which was that orders shouldn't be made which cause any injury. And then, from then onwards, the next 10 pages deal in detail with the fact that there is no basis for damages without fraud, conspiracy, or malicious prosecution. So that's going till the end of that judgment. And then Mr. Justice Murphy.
And where's the reference to malicious prosecution?
847.
Thank you.
And you'll see the first paragraph there. Exceptions to these principles include orders and judgments produced by conspiracy, malicious prosecution, or fraud.
It derives solely, the jurisdiction derives solely from the undertaking as to
It does,
damages
yes.
given at the time of the making, yes.
Mr. Justice Murphy then goes on to consider all of this in his judgment, including pointing out at 851, at line 11, that the order wouldn't have been made, or it was highly unlikely that the order that was obtained ex parte would have been granted had the appellants been represented by a counsel, and accordingly it was a deliberate abstention of the banks from informing the appellants of their intention so to apply, which in the first place enabled them to obtain it. And so in this sense, any damage suffered by the appellants as a consequence of the order is referable to the action of the banks in seeking it in this matter. And then the court goes, Mr. Justice Murphy goes on to consider at 854, about halfway down the page, the whole point of getting an undertaking is because without the undertaking you have no basis for obtaining damages.
Yes.
And the same point is made halfway down page 855. And going through all the authorities, including all the English authorities, to make this clear. And then at 859, I'm sorry, that's...
Yep.
That's not correct. If I just take you to Mr. Justice Brooking, he starts, as I rather started, which is that the law is not always the true embodiment of everything that's excellent. Mistakes are made from time to time, and this case raises the question who is to pay for one of them. And that's really where we are in this case. Who needs to pay for the fact that the court order should not have been made, it turns out. And then at 861, he goes on to consider the question of restitution, which is then taken up again at 864. And these are all cases where there's been money paid
Yes.
or property passed. And he then concludes at 866 that one can get restitution of property or money passed, but not losses caused. 867, he points out the same as the rule in America.
But the application here doesn't depend on the point that the order should not have been made anymore, does it?
I'm simply dealing with this to close off the points of the way that it was put against us, as opposed to where we've ended up now. And possibly where Mr. Justice Brooking ends at 872, just above what is 20, Mr. Justice Brooking points out that this is not a principle which enables a horse that is bolted to be thrust back into the stable.
Right. Okay.
And that is what we say Malone and Friends are trying to do here.
Right.
Now, that I think...
Well, they're really trying to appeal against paragraph 63, in effect.
Yes, although they say they're not, and they say that's not actually how they put it before the court. But what they are trying to do is to get your lordships to exercise the jurisdiction now on a Section 195 and a common law assistance, power of assistance, that were made in relation to documents we haven't got.
Could they have appealed on at least the first part of paragraph 63, either to be responsible for?
Yes.
I mean, the trouble is, the way that in the judgment the point is described is in paragraph 8 on page 59, which simply relates to the failure to obtain a cross-undertaking in damages.
Yes.
On one view, Justice of Appeal Bell was, in paragraph 63, going on a slight frolic of his own in discussing an order that the liquidators be responsible.
Yes, and that's what Malone and Friends says.
And to be fair, that's what he says, but yeah.
So Malone and Friends says one of the reasons why an order should not have been made was because no cross-undertaking was given, and then this is what is said about it. But I think we get back to where we started, which is this is not a case where such an order should be made. It is not a case where just because the orders have fallen away, the public interest falls away. It is not a case where the liquidators or the estate, having got no benefit, should pay £600,000 or dollars or whatever it finally ends up as for documents it never got. Because, going back to the point Lord Sumption made, that would put liquidators at extraordinary peril in getting these sorts of orders.
Well, what it might do is to say that if the liquidators want to get the orders, you ask yourself, at the point they get the order, knowing it can be appealed, is the fair way to protect the liquidators to say that the liquidator should say, if they're going to appeal, we're happy for it to be stayed. We don't want them to spend the money because we may be at risk, because the court may make the order which you accept it could make at the end of the day. We want to be protected against that. And since we are the ones running this show, applying for this order, the respondents are, as it were, innocent parties dragged into it. It's up to us to make sure that we're protected if there's a successful appeal.
Well, except that in many cases there will be limitation issues, because what often happens on 236 orders is they do get appealed. And if what happens is that there's always a stay, then the liquidator sits around with no documents until those documents come in. Now, in fact, in this case, there was what was called the carve-out order, because there were limitation questions and there were also ongoing proceedings. So not only the proceedings that the liquidators were going to bring, but the proceedings that were brought against the company in liquidation.
But it might be said that this is all understandable concerns of the liquidators, but if you're asking who should bear the costs of it all going wrong, why should those sort of considerations penalise people in the position of PwC?
Well, the answer, I think, then goes back to the public interest question. And that's why I say it's important that just because these orders shouldn't have been made, it doesn't mean that you should pull away the public interest question.
It's all a question of discretion when it comes to it at the end, though.
Well,
you concede that there's jurisdiction, so it's just a question of just how to exercise the discretion in all the circumstances.
yes, but I think it is important as to the weight on which one puts any of these particular
But
factors.
much depends upon the facts of the particular case.
That's right, but I think what Lord Neuberger was saying, then what one should do, I was saying, well, liquidators would be put in this impossible position because they might be running up costs which they might have to make if the order wasn't properly made. Lord Neuberger said, oh, well, then that should be stayed. So I was saying...
Well, I'm saying either it should be stayed, or if you're deciding who should bear the cost, it might be said that the liquidators are taking the risk. In the end, the creditors are ones who want this. They're the ones who are going to fund it because it's going to come out of the estate. If you say, where does the balance of fairness, unfairness lie? All right, they're both the victims of the system, if you like. But the person who chooses to go for the order, the person who aims to benefit from it, is the estate, ultimately, not the liquidators personally, but the estate they represent.
But if this, but then...
And why should, as it were, an innocent third party who's got dragged into it pay the cost of the risks of litigation, the risks of the law not going the way people expect? Why should it? Doesn't the justice suggest that it should be the liquidators?
But if,
the estate?
if this is a general principle for all liquidations, so in other words, on day one of a liquidation, the liquidator comes in, doesn't know anything, goes to people who look like they're innocent third parties. And your lordships may recall that during the course of the appeal, there was some suggestion about whether or not we could just get these documents by suing PwC, who were remembering they were the auditors of these companies, remembering that we don't have a large number of the documents of these companies because they were removed and have never come back. So you're saying as a matter of general principle, a liquidator who comes into a company should put the assets of the estate on risk in relation to a 236. Now, of course, first of all, a lot of estates don't have that money. So you might be talking about the liquidators themselves taking that risk.
Well, the liquidators would no doubt get an indemnity if they were well advised before they took on the risk.
Well, not if there are no assets to get an indemnity out of.
But you're not saying Avon and Burford is wrongly decided, are you?
No.
So a lot of the arguments you've just been putting would be are negated by the effect of Avon and Burford, aren't they? Because the liquidator in those sort of cases is still going to be at risk.
That's true, but those are the exception. Those cases are the exception.
Yes.
So...
what you're saying, I'm saying, is that effectively the liquidators are going to have to foot the bill every time, and you're saying that can't be right.
Yes.
I see. Thank you.
And it is all slightly technical, the underlying position, isn't it? It rises because we have two different islands, both with the common law, and a firm of accountants which is determined not to disclose the information and documents. I'm not quite sure if one doesn't know what's in the documents or why they were so vigorously resisted for disclosure. It's quite difficult to judge the underlying position.
Well, quite, although if one's trying to set down a general principle, then one should assume that in some circumstances those papers would contain something interesting to us and in some circumstances they wouldn't. But of course, yes, this would all be much easier if your lordships had made a different order. So if you want to revisit that. But yes, I agree. I think
at the discretionary level, the position is not perhaps quite as attractive or as clear as it seemed at the question of at the level of jurisdiction.
Yes.
That's all I was suggesting. I mean, there's a certain technicality about the fact that the documents couldn't be obtained here, simply because of the way in which the various entities organise their affairs and where they happen to be, and so on. in a different world, if we didn't have offshore financial centres, they'd all be in one place.
Or if they all had the same laws.
If they had the same laws, exactly. That may be a lesson for the relevant.
Well, we'd be out of a job then, probably.
I think that lesson is very much being taken.
That they should harmonise the legal principles, yes, to enable better cooperation.
As you might expect, there's been rather a lot of discussion since Your Lordship's judgment on those sorts of issues. But, of course, offshore financial centres have their own reasons for doing things in their own ways.
Right.
But that's where we are, I think. So,
No, I actually think that we can discuss that.
Milena Junior, Mr. Robbins was just saying it might be the case that the exercise of the discretion would be pretty obvious if you knew that the person was not somebody mixed up in anything and was a truly independent, innocent third party. But of course, one would never know that until you get the documents. And as my Lord Mance put it, that they're resisting pretty hard after seeing them.
I mean, but the answer is that
So you mean they must have something to hide?
we have to disclose, we have to make a judgment now as to whether to exercise the discretion in principle. We can't sort of half exercise it because there's nothing further on which it could be dependent. These documents are never going to be seen or anything. We're never going to know more.
But it is, I think, important that we bear in mind the way in which this will operate in the ordinary insolvency, which is effectively if there is a discretion which can be exercised at the end in relation to an order which shouldn't have been made, and that in and of itself is the most important point, then that's going to cause some very serious problems to liquidators. And of course, it's not just liquidators, all sorts of office holders, trustees and bankruptcy.
Might it be said that if we go the other way, it will encourage liquidators to be too gung-ho?
Well, yes, but remembering that there is quite a serious...
They ought not to be obtaining orders which the court has no jurisdiction to make.
Well, then you are, I think, back to the question of whether or not this is effectively being used as a remedy for an order that shouldn't have been made. Because after all, it's not as if we didn't go through several sets of courts who thought we did have the right to them, including those in Bermuda.
Would we be encouraging, if we went down this line, no applications or no reference being made at an early stage? Because, I mean, Mr. Chivers's case has been that he did his best to get it at an early stage. But if we accept this part of this alternative approach of his fallback position, then he didn't have to make any applications at an early stage. He could simply sit back. I mean, in practice, I think the matter should be raised at an early stage, partly to give people in your client's position notice.
Yes, and that in fact is what happened in both BCCI and Bank of America and in Aveling Barford and for that matter Clover Bay, because usually what happens is the respondent says, I don't want to pay for this. And the court usually says, tough, it's a public interest.
I suppose the answer is that if you didn't raise it at an early stage, that would be a discretionary factor, so that it will in future be a good idea for parties in Mr. Chivers' client's position to do what he says his clients did, raise it. If it's wrongly refused, then, of course, it can't be blamed at a later stage if they apply.
Yes, although I wouldn't like it to be suggested that that's because somehow the liquidators have an obligation to raise the points of question of costs of compliance at an early stage.
No. I think, for my part, probably the onus is on the person who wishes to have protection at a later stage to raise it.
Yes,
then it'll be a discretionary factor that they did raise it. At least will have put your clients on notice.
Yes, but then we still go back to the same place where we started, which is that the liquidators would effectively have it hanging over them. And then we get back to the question of, and as between two sets of innocent parties, who bears the costs? And that is why, in that context, the public interest point is so important, and why it is not the case that the public interest falls away just because the order shouldn't have been made. Because the question is, was there a public interest in making the application in the first place?
In this case, the matter is so complicated by the fact the order shouldn't have been made. I mean, what one would normally expect is the PwC to have made an application for a stay pending appeal. But as I understand from what Mr. Chivers said, the judge effectively forestalled that by making the order that he did and giving them time pending their application and their appeal. So that wasn't really on. Is that right?
Well, I'm not sure that's quite right, because I think there is a difference between the 2 points. They could have made an application for a stay. The extension of time for compliance was because they said it was going to take them 4 months to put the documents together.
But the judge dealt with the possibility of an appeal when he agreed the period for them complying, as I understand it. I mean, we may have to look at the precise terms, but one would normally expect an application for stay pending appeal, and then that to be considered on its merits.
Yes, and of course, by the time they made that application to the Court of Appeal, they say that they'd already...
They'd done the work, exactly.
But what they didn't do was make an application to the Court of Appeal for a stay pending appeal.
That's true. Yeah.
The judge's order only solved the question of disclosure. It didn't solve the question of costs.
No, it only solved the question of timing.
But it didn't deal with the possibility of what happens if the Court of Appeal, or indeed the board, reverses the decision.
Yes, but that's, of course, normally what one would do is make an application for a stay to the instant court, and if it refuses it, make it to the appeal court, and
Pending
otherwise...
appeal, right. And there was no point making that application to the Court of Appeal because the work had been done.
Right.
Okay.
Would it be possible, and would it be better in this type of Aveling-Barford BCCI case, to fashion some sort of, once the point's raised, implied express undertaking, which would actually then, firstly, make the position clear in principle, but also would have a discretionary element to it, because the implied undertaking is to pay such costs as the court may think it appropriate, isn't it? So doesn't it have a discretionary element built into it, or does it carry a sufficient prima facie presumption to make that
I think
unreal?
that you would only ever make that order if you thought it was a case in which you would eventually make that order.
It normally only goes to quantum, I think.
Yes.
It doesn't go to the
reservation.
No, it doesn't. Because of where we start, which is normally those orders are not made.
Yes, I think okay.
I suppose the answer is anyway that the Aveling-Barford formula is pretty similar. It's a warning that matter will be considered at a later stage.
Yes.
And that has a complete discretion, though it goes further.
Yes.
Yeah, I see.
Yes.
And unless there's anything else.
Thank you very much indeed, Mr. Tube. Thank you. Mr. Robbins. Mr. Chivers.
My Lords, working backwards, as between 2 innocent parties, who bears the costs? The answer is the one who obtained an order without jurisdiction, and indeed in respect of an appointment in which they had been made appointed without jurisdiction as well. It's not a difficult question to answer in principle. The proposition, as my Lord Newberger put it, that what we were really saying was that the liquidator foots the bill all the time, that's not right, although if one says the liquidator foots the bill all the time, when he wasn't properly appointed liquidator and the court had no jurisdiction to make the order, perhaps isn't a bad way of putting it. But that's an exercise of discretion. The question is, if the court is exercising its discretion, does the fact that the order was made without jurisdiction come into play? Yes, it does. As my Lord Sumption says, it knocks away any public interest argument altogether.
But it doesn't, because it will obviously put off liquidators and make them very timid if they know that if they have their application is held not to be valid eventually, they will have to foot a substantial bill.
Well, my Lord, the ordinary position is that the question of the liquidator's existence as liquidator is very rarely under challenge. This is an exceptional case. The basis on which this order was set aside was not because it was an improper exercise of discretion by the learned judge. It's because the winding up itself fell away. It's a very exceptional case.
And
so
also, it's a case where the liquidators, where you asked for the cost to be in the form of a cross undertaking, and the court specifically refused to do that.
Well,
So
the Court of Appeal refused. The first instance judge didn't specifically refuse.
Well, he didn't deal with it.
He didn't deal with it.
You could have gone back and said you haven't dealt with it, but you accepted he did not dealing with it and went to the Court of Appeal.
Oh, my Lord, we were at the Court of Appeal by then. But the question of who is at risk, clearly the liquidators, even on their own basis, knew that they were at risk if the ordinary principles were applied, which my learned friend accepts, applies. Even if we hadn't applied before the learned judge, they would have been at risk on their basis. They also knew the scale of the cost. We'd told them how much it was likely to take. We'd told them in evidence before the learned judge what the exercise in Cayman had cost. That had cost $250,000 in respect to the limited exercise in Cayman. So they knew they were at risk. They also knew that this was an application where they were asking for compliance before the matter could be finally dealt with. And so there comes the risk and the question of who asks for a stay, who gets the stay. If the liquidator knows and insists on compliance before the matter has been finally determined, knowing also that the court has a discretion in any event to order them to pay the cost of compliance, it's difficult to see that it's unjust to require them to pay the burden of that. My learned friend says, well, the liquidators didn't get any benefit. It's not a restitutionary case. In one sense, of course, they did. The liquidators got the benefit of a great deal of work being done in anticipation, as they hoped, of an order being made, that it be handed over. Yeah. That's the benefit they got. If they say there was no benefit, they didn't need to have that order complied with, save for the handing over. That was clearly something that they anticipated was of benefit to them, or it wouldn't have mattered. And indeed, they were pressing, my learned friend says, for the carve-out documents right up to this court, and were insisting that they get them absent stay. So to say that the justice of the case somehow falls in favour of the liquidator, or the creditors, who after all are the ones who are paying, as the innocent parties, neither here nor there. My lord, so far as bond is concerned, it's a case that doesn't trouble us at all, because we don't say that there is any other basis on which the costs, so far as the cross-undertaking damages point, ought to be made. And all one needs to know about bond is that, as the court held in that case, the implied undertaking, which is given in England, which has been acknowledged since 1890, doesn't run in Australia, in Victoria. That's all you need to know about bond. And you see that at 871 and at 857. Okay. That's the end of that. Although Bond did recognise the Schmitten and Folks exception might run where there's an officer of the court in play. But subject to that, it doesn't matter. My lords, the G point, my learned friend still seems to be asserting that the G implied undertaking point is wrong. It isn't. There's nothing in any of the cases that you have seen that casts doubt on the implied undertaking basis. The two cases that my learned friends referred to at A425, that's their submission, at subparagraph 2, which they say proves the point because the undertaking, the injunctions were discharged because undertakings hadn't been given. The reason they were discharged was because of abuse of process. In both of those cases, they were abuse of process cases, and in both of those cases, the plaintiffs were trying to give an undertaking. They were prepared to give the undertaking, if you look at those cases.
So what was the reference?
It's my learned friend's submission at A, bundle A, tab 4.
Paragraph 25.
Yeah. Paragraph 25.
Thank you, yeah.
Subparagraph 2. And those cases, Spanish General Agency and Free Go and Filhagi, those injunctions were knocked out on abuse of process. Both plaintiffs were trying to give undertakings to the court, but it was too late by then. Their failure to do so in a proper manner was abusive. So there's nothing in any of the cases that touches on the implied undertaking where there's an injunction. There's nothing in Bond that touches on it, because that's dealing with the Australian practice, which they acknowledge is different from the English practice. And indeed in Kerridge, a case in New South Wales, which my learned friends put in their bundle but hasn't been referred to, it expressly referred to Howard as a case which established that in England there was a practice in relation to undertakings. So there's nothing in that. The interesting point, I thought, from my learned friend's submission was that my learned friend accepted that this court had a jurisdiction under Section 195 in relation to SAAD to order the payment of costs, and we've discussed the exercise of that discretion. The question then arises, well, what's the position in relation to Singularis? If Singularis is taken out of the 195 position, as my learned friend acknowledged, we are then simply in a common law order for the production of documents. And it may not be a Norwich Pharmaceuticals case, because of course there wasn't a Norwich Pharmaceuticals jurisdiction, but it is nonetheless an attempt to get a common law mandatory injunction for the production of documents. And that carries with it an implied undertaking to pay the costs of those production of documents, not on an inter partes basis, not on as a cross undertaking in damages, but as the price for getting the order. My Lord, that's so standard that a party must be taken to undertake that. My Lord, those were my points in answer, unless I can assist you further.
My Lord, I'm sorry, just on one point. I think my learned friend said that, that the JOLs knew what the costs were in Cayman that had been incurred in the Cayman exercise and therefore should have known that they were on risk. My instructions are that PwC did not get their costs of the exercise in Cayman. They didn't apply for them.
Well, my Lord, that leads me to another point which I think had been raised between my Lord, Lord Mance and my learned friend, which is the contents of the documents and what's behind PwC's opposition and so forth. My Lords will be aware that there were UAE confidentiality issues involved.
We can't
with respect, it wouldn't be proper for any aspersions to be cast on PwC's.
We just don't know.
Equally, the position in Cayman and the reasons that PwC has not applied in Cayman are for another day, and for Cayman.
Well, we're very grateful to you both for your submissions, which were very helpful, and we will we're also grateful for your written submissions and to all those involved in preparing them. We will consider our decision on this matter and humbly advise Her Majesty in due course on the advice will give us. Thank you very much indeed.